Good afternoon to you. We will continue with the Constitution. In the last class, we have discussed tribunals, both administrative tribunal and the tribunals in respect of other matters. Today, we will see other legal institutions. Other than tribunal, what are the other legal institutions? These are all very small topics, nevertheless important. Article 233, Article 233 to 237 deal with the organization of subordinate courts and their independence. Governor of the state, in consultation with the High Court, has the powers to appoint, promote, and post district judges in the state. As you know, the qualifications are for being the district judge. The qualifications are: number 1, should not be in central or state service. Number 2, should be an advocate or pleader for 7 years. Number 3, duly recommended by High Court. Should not be in central or state service. Should be an advocate or pleader for 7 years. And he should be duly recommended by the High Court. Sorry. Appointments of persons other than district judge to the judicial service of the state are made by the governors after consulting the High Court and State Public Service Commission. Two consultation agencies, number 1 is High Court and the other is State Public Service Commission. In fact, normally there is a competitive examination conducted by the State Public Service Commission to recruit the judicial service officers. So, first we dealt with the district judge. What are the qualifications? What is the selection process? Then, other than district judge, the services of judicial service of the state, who is making governor, and after consulting normally High Court and State Public Service Commission. I also told you normally there will be a competitive examination conducted by State Public Service Commission to recruit the judicial service officers. The control over subordinate courts, including district courts, regarding postings, promotion, grant of leave, etc., is with the High Court. So, this is the point. Now, what do you mean by district judge? First, let us define district judge. District court judge includes the judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of small cause court, chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, and assistant sessions judge. All these categories the district judge apply. So remember, who is the district judge, district court judge? It includes the judge of a city civil court, additional district judge, joint district judge, assistant district judge, chief judge of small cause court, then comes chief presidency magistrate, additional chief presidency magistrate, sessions judge, additional sessions judge, assistant sessions judge. In addition, governor can direct that the provisions relating to persons in state judicial service would also apply to any class of magistrates. So it's the governor's discretion. The organization structure, jurisdiction, nomenclature of a subordinate judiciary are laid down by the state. They may differ from state to state. In fact, there are 3-tier civil and criminal courts below the High Court. Below the High Court, there are 3 tiers. The first layer is District and Sessions Judge Court. This is the first layer. This is again divided into 2 groups, civil side and criminal side. Under civil, the first layer is Subordinate Judge Court, below that Municipal Court. On the criminal side, there is a Chief Judicial Magistrate Court, below that Judicial Magistrate Court. So, this is 2. District Judge is the highest authority in the district. He has both original and appellate jurisdiction in respect of both the civil and criminal matters. In other words, a district judge is also the sessions judge. When he deals with the cases, he is called, if he is dealing with the civil cases, he is called a district judge. Remember, a district judge is also a sessions judge. When he deals with the civil cases, he is called a district judge. When he deals with the criminal cases, he is called a sessions judge. Kindly remember, sessions judge means criminal cases and district judge means civil cases. The district judge has both the judicial and administrative powers. Appeals against his orders and judgments lie to the High Court. The sessions judge can impose any sentence, including life sentence and death sentence. However, the death sentence passed by him should be confirmed by the High Court. So, if a sessions judge has imposed a death sentence, that has to be confirmed by the High Court, which I have already told you. Even with the accused has made an appeal or not, does not matter, it has to be confirmed by the High Court. Below District Court and Sessions Court, there is a court of subordinate judge on civil side. Similarly, on the criminal side, there is a court of Chief Judicial Magistrate. The subordinate judge has unlimited monetary jurisdiction in civil cases. A subordinate judge is also known as Civil Judge of Senior Division or Civil Judge Class 1. The judicial magistrate can try criminal cases which is punishable with imprisonment up to 3 years. In some important metropolitan cities, there is city civil court on the civil side and metropolitan magistrate on the criminal side. Some states and presidency towns established small cause courts to decide the cases of small value in a summary trial. Their decisions are final. Now, in some states, panchayat courts try petty civil and criminal cases. They are variously known as Nyaya Panchayat, Gram Kacheri, Adalati Panchayat, Panchayat Adalat, etc. Article 39A of the Constitution provides for free legal aid to the poor and a weaker section of society to ensure justice for all. You know, Article 39A is a directive principles of state policy, which was added through 42nd Constitutional Amendment Act 1976. In addition, Article 14 and Article 22 gives an obligation to the state to provide equality before law and a legal system of providing equal opportunity to all. In pursuance of these principles, Legal Services Authorities Act 1987, very important, Legal Services Authorities Act 1987 was enacted to monitor the implementation of legal aid programs. In addition, the Act envisages laying down the policies for making legal services available to all under the Act. Accordingly, National Legal Services Authority, NALSA. What is that NALSA? National Legal Services Authority has been set up. In each state, a state legal services authority, and in every high court, a high court legal services committee has been set up. Similarly, district legal services authorities and taluk level legal services committee were also constituted in districts and in many taluks to give effect to the policies of NALSA. What is NALSA? National Legal Services Authority. The purpose is to provide free legal service to the people and to conduct local adalats in the state. There is a Supreme Court Legal Services Committee to administer implementation of free legal service programs insofar as it relates to Supreme Court. There are three functions attached to these state, district legal services authorities and taluk legal services committees. What are the three functions? Number one, to provide for free competent legal services to eligible persons. Number one, to organize local Lok Adalats for amicable settlement of disputes. Number two. Number three, to organize legal awareness programs in rural areas. These are all the three functions allotted to what is known as state, district legal service authorities as well as taluk legal services committees. Now, what do you mean by free legal service? What does it include? It includes number one, payment of court fees, process fees, and other charges for legal proceedings. Number one, to provide the services of lawyers. Number two. Number three, to get the orders and other documents required for the legal proceedings. Number three. Number four, to prepare appeal paper book, including printing and translation of documents. These are all the services which are availed through free legal service. Now, who are eligible? What are the criteria for eligibility? Number one, women and children. Very important, women and children. SC, ST, industrial workmen, victim of mass disaster, violence, flood, drought, earthquake, industrial disaster. Then fifth category, disabled persons. Now sixth category, persons in custody who cannot be helped by anybody. Persons with annual income not exceeding 1 lakh. Not exceeding 1 lakh. For Supreme Court Legal Services Committee, the limit is 1.25 lakh. Then, eighth category, limits of victims of human trafficking and beggar. Now, let us come to Lok Adalat. What do you mean by Lok Adalat? It is very important. It's two questions or one question can come. What is Lok Adalat? It is nothing but a forum. It is a forum where the disputes pending in the court are at the pre-litigation stage are settled in an amicable manner. It is an old system of adjudicating the disputes which was prevailing even in ancient India, though it is relevant today also. What do you mean by local adalat? Lok Adalat means people's court. This is based on Gandhian principles. It is the one of the components of alternative dispute resolution system, ADRS, alternative dispute resolution system. What is the purpose? The purpose is to provide inexpensive, expeditious justice to the litigants and to reduce the heavy burden of work in the subordinate courts as well as in the high courts. In these proceedings, if you see, it is only a win-win situation for both the parties. There is no victor, there is no vanquished, there is no rancor, there is no enmity because both the people win by mutual understanding. One person gives, one person takes. One person gives up, another person gets. One person forgets, and another person forgives. So, this is a mutual consultation, mutual understanding to avoid litigation. The first Lok Adalat camp in post-independent India was organized in Gujarat. Where it was organized? In Gujarat. When it was organized? In 1982. It was very successful. It was initially voluntary and there was no legal backing. However, it was given a statutory backing under Legal Services Authorities Act. Remember, it is the same Legal Services Authorities Act of 1987 gave birth to the Lok Adalat also. This act made provisions regarding number one, the State Legal Services Authority of District Legal Services Authority or Supreme Court Legal Services Committee or High Court Legal Services Committee or Taluk Legal Services Committee can organize Lok Adalat at such places and at such intervals. All the four, remember. Generally, a Lok Adalat consists of one judicial officer who is the chairman and an advocate plus one social worker as members. A Lok Adalat organized for an area shall have jurisdiction to determine the disputes not only of those cases pending before the court but also which are at the pre-litigation stage, that is those which have not been brought before the court. So all these things can be covered under the Lok Adalat organized for a particular area. And who can organize? It is organized by the State Legal Services Authority or District Legal Services Authority or Supreme Court Legal Services Committee or High Court Legal Services Committee or Taluk Legal Services Committee. They can organize Lok Adalat at such places and at such intervals. This is the nutshell, the Lok Adalat. We will continue with the same topic tomorrow in the next class. Thank you very much.